Good afternoon, everyone. I'm Harold Kim, president of the U.S. Chamber Institute for Legal Reform, and thank you for joining us from your couch, from your dining room, your home office, or wherever you may be today. Today's going to mark the launch of the first webcast episode of ILR Briefly. This is going to be a series of short research and live video events examining the latest trends in litigation and emerging legal reform issues of importance to the business community at large. Now, at the beginning of this year, we thought that we would all be together in the U.S. Chamber's Hall of Flags for our annual Legal Reform Summit. But those plans, unfortunately, were postponed in the wake of the current pandemic. So we adjusted quickly, and we're going to start delivering important content through virtual meetings like this during the course of the year. Call it the new normal, but expect to see more of these ILR Briefly events in the future. Now, today's event is going to focus on escalating problems surrounding class action securities litigation. It was about 25 years ago when Congress passed the Private Securities Litigation Reform Act, or the PSLRA, in response to an explosion of class action securities lawsuits that, to put it mildly, were abusive and wreaked untold havoc in our capital markets. Now, if you fast forward to today, the problem has reemerged and it's screaming, absolutely screaming for a solution. Now, we've seen a couple of securities filings in the wake of the coronavirus outbreak, and I would imagine that we're going to see more in the coming weeks and in coming months. So the way we're going to structure this is to do an initial 30-minute conversation with our two guests today, and we're going to follow that up with a few minutes of question and answer from the audience. And so in terms of how you ask these questions, all you have to do is enter the questions into the chat bar that hopefully is on the side of your screen. And we're going to address these questions at the end of our initial discussion. Now, some of you may have already seen the companion paper for this event that we released just last week, which was on Friday, and it's got a pretty simple title, ILR Briefly, an update on securities litigation. You can find this paper on our website, instituteforlegalreform.com, and I would urge you to take a look at it. We're really lucky to have the author of this paper with us today, none other than Mr. Andy Pincus from Mayer Brown. Many of you know Andy. He is a securities litigation expert, an expert when it comes to arbitration, a veteran Supreme Court litigator. I tend to think of Andy as a super lawyer in Washington, and he hits all of those qualifications across the board. I'd also like to welcome Kevin LaCroix of RT Pro Exec. Kevin is probably better known for being the editor of the D&O Diary, and he really is an industry thought leader when it comes to securities class actions and management liability issues. So gentlemen, thank you both for being here with us today. Andy, why don't we just dive right into this? Last February in 2019, the three of us were at the National Press Club talking about how the plaintiffs' bar has basically eroded the protections that Congress put into place with the PSLRA, and how securities class action filings were basically shattering all kinds of records. So through this newly released research, Andy, why don't you tell us what's happened since then, and basically, are things getting better or are things getting worse?
Thanks, Harold, and it's great to be with everyone, and thanks to ILR for putting this event together. I think the short answer is things are getting worse. When we were together a little more than a year ago, we were talking about this dramatic new normal that we'd seen for 2 years, record-breaking levels of securities class action filings. And I'm sorry to report that we have another record-breaking year, not the kind of record that we like, but a record-breaking year in terms of filings. Again, staying at this incredibly high level, which, as you can see, is more than double the average for the 20 or so years after the PSLRA really took effect. And what this chart shows, I think, is even more disturbing, is the likelihood of a public company being sued. And it's really staggering. 1 out of 11 public companies are sued every single year. And again, 2.5 times the average for that 21-year period. So we're seeing continued incredibly unusually high levels of securities litigation, and really for the same reasons that we've been talking about for the past 3 years now. One is this explosion in cases based on mergers and acquisitions by public companies, where we've seen virtually every deal over $100 million be the target of at least one and often more than one lawsuit. And then this relatively new phenomenon of event-driven litigation, where unlike in past years where securities litigation was really focused on financials, the company's financials, allegations of fraud that led to misstated financials, now we really have a disproportionate number of claims that have to do with reversals in the company's underlying business. Maybe there's a data breach. Maybe there's some kind of problem allegedly with the company's products, and that doesn't just translate into a class action by the folks who claim their data was misused or by the folks who claim they were injured by the company's product. It also is accompanied by a securities class action alleging that the company should have disclosed something before or had some misleading disclosures in the past that led to this problem. So the short answer, a really continued dramatic high level of securities class actions.
Well, Kevin, you follow a lot in terms of what's happening in the trenches. You have a great blog. I read it all the time. So what do you think is driving this? Is it that there are just more lawyers on the scene? Is there more questionable corporate conduct? I mean, how do you put your thumb on it? And what kind of insights can you bring to us?
Well, Andy mentioned a couple of the important aspects of this ramp up in securities litigation over the last 3 years. One, of course, is the shift of merger objection litigation from state court to federal court. But it's easy to get distracted by that factor because even if you take out the merger objection litigation and just focus on the traditional or core Section 10, Section 11 liability claims, we're still at record levels. If you take the merger objection cases into account, it's about 1 out of 11 public companies was hit with a securities suit during 2019. But it's still roughly a 5.2% litigation rate, even just with respect to the traditional litigation. So roughly 1 out of 20 companies is getting hit with a traditional lawsuit, which is really more than double the historical averages. What's behind all this? I think that this likeliest explanation is just changes in the plaintiffs' bar. There's a small group of newly active plaintiffs' lawyers who are much more aggressive, much more willing to file lawsuits that rather than being about traditional sources of liability, such as accounting or financial irregularities, they're filing what Andy correctly described as the event-driven litigation. And we're seeing this even as today in the lawsuits that, as you mentioned, Harold, that are being filed about the coronavirus outbreak, clearly another species of the event-driven litigation phenomenon. It's no accident that as the number has gone up, more cases are getting filed. More lawsuits are not being filed because there's more fraud. More lawsuits are getting filed because there's a newly aggressive sector of the plaintiffs' bar that's just filing more lawsuits.
You know, I'm wondering if we could go back to the previous chart showing the increased number of not only just talking about the filings, but the chances of being sued as a publicly traded company. And I'm wondering, Andy, you know, as a matter of perspective, were we seeing these types of statistics back 25, 30 years ago, which prompted Congress to do something about this during the crisis at that time?
No, we're actually seeing much higher levels. Part of that is a function of lawsuit numbers. Part of it is a function of the fact that there are just fewer public companies than there were in the late 1990s when the PSLRA was being debated and ultimately was enacted by Congress in 1995. So these are higher numbers, which makes it all the more shocking in terms of what's going on right now.
Right. Well, Kevin, you mentioned event-driven litigation, and the one thing that is kind of the big elephant in the room here is what's going to happen in the wake of this current pandemic outbreak. We've seen a handful of securities litigation class action lawsuits being filed. We have certainly heard concerns about companies that have taken voluntary actions to confront the challenges to protect their employees, to sustain supply chains. And how that could translate into allegations that somehow shareholder value was minimized when companies are trying to do the right thing. I'm wondering if you could speak a little, Kevin, about some of your insights with regard to this new strain of litigation potentially that we could be seeing in the wake of this national or international, shall I say, crisis.
Well, I think for those of us in my industry, which is the directors and officers liability insurance industry, I think the assumption is that there will be coronavirus related claims. There will be disclosure claims. There will be mismanagement claims. There will be insolvency claims. We've already seen disclosure claims. Norwegian Cruise Line and Inovio, a biotechnology company, have been sued in securities class action lawsuits. I think the assumption in our industry is that there will continue to be disclosure type claims filed, that plaintiffs' lawyers will seize on statements by companies about their ability to rebound, about their financial stability, about their cash flow, liquidity positions, and that the uncertain recovery that I think we all know is ahead of us will result in some unexpected developments. And I think we can count on the plaintiffs' bar to seize on unexpected developments with the hindsight allegations that companies misled investors about their readiness, about their financial stability, about their financial condition. And I think this will play out over time. I don't think this is something that's going to be just over the next couple of months or weeks. I think this will be as long a period as 18 to 24, even 36 months as companies struggle with the impact of the crisis we're all going through, particularly from a financial standpoint.
Thank you, Kevin. Andy, what say you?
I think, unfortunately, if past is prologue, we've always seen the plaintiffs' bar wanting to seize on events as a grounds for bringing new lawsuits. So I think that's likely to happen. And it's especially likely to happen given the volatility of the market these days. You know, one of the things that creates large pots of potential damages in securities litigation is the volatility of the stock during the alleged period of the misrepresentation. And obviously, we're seeing tremendous volatility now that potentially creates a large pot of money for plaintiffs' lawyers to go after.
Yeah. Well, I'm sure we will end up getting a few more questions during the Q&A about this, but maybe what we could do is shift gears a little bit and talk about the 2018 Scion Supreme Court decision, which basically opened the door to state court securities litigation, specifically when it comes to 33 Act filings and claims. This was relatively a nascent decision when we again met back in February. I think we talked about the consequences of this litigation. And Andy, I'm wondering if you could talk a little bit about some of the findings that you've seen with respect to the post-Scion decision and its impact when it comes to state court filings.
Sure, and I think the sad news is what we were worried about a year ago is really coming to pass with a vengeance. If you look at the chart that's on the screen now, you can see that state court filings have jumped substantially, that a large number of cases are being filed in states other than California and New York. So these cases are really getting scattered in state courts throughout the country. And one of the things that this chart doesn't show is the number of cases where there is an action based on the same alleged underlying facts pending in state court and in federal court, and that's about half of the state cases. So one of the tremendous evils of Scion, there really are two. One is that a company may be forced to defend the same claim in two different forums where there is really no mechanism for the cases to be coordinated, and so that obviously drives up discovery costs tremendously. The other thing we're seeing is, not surprisingly, state courts are not experienced in adjudicating these cases. And so we're seeing dramatically different dismissal numbers in state and federal court. Basically, only about a quarter of the cases in state court are dismissed, while the number is 43% in federal court. And obviously, as people listening know, The motion to dismiss is the critical stage in one of these cases, because once a case gets past the motion to dismiss and past the class certification stage, it almost certainly is going to settle. So weeding out cases at the motion to dismiss stage is very important. And what we're seeing is that state courts, probably because of lack of experience, are just not as willing or able to do that. And that's a real problem for the companies that have to defend these cases.
Hey, Andy, just a quick follow-up question. I mean, looking at this chart here, I mean, California and New York really should be no surprise, but in terms of the additional states, can you give us a sense as to where these cases are actually being filed?
I mean, they are really cases throughout the country. There are a bunch in Illinois. There are a bunch in I think, basically 8 or 10 other states. So they're very widely distributed. And, you know, it isn't surprising that some plaintiffs' lawyers actually want to look for inexperienced courts, because that's where they have the best chance of beating a motion to dismiss, having the case linger on, and putting maximum pressure on the company to settle.
Yeah. Well, turning to you, Kevin, perhaps I would just describe this question as a glimmer of hope, perhaps. I'm wondering if you can give us some thoughts about the recent Delaware Supreme Court decision, which basically allows corporate bylaw forum selection clauses that can mandate a federal forum for shareholder litigation against a company. And do you think that this could be something that might have an impact on the migration of some of these 33 cases under Scion going into state court?
Well, you're right, Harold. Shortly after the Scion decision came down from the U.S. Supreme Court in March 2018, there was a widely circulated idea that perhaps companies could assure that they would have a federal forum for their Section 11 litigation rather than facing a state forum, or worse, both state and federal. And so a number of companies adopted articles of incorporation that specifically specified a federal forum for Section 11 litigation. And 3 of those companies completed IPOs in late 2018. A shareholder of the 3 filed a declaratory judgment action in Delaware, seeking to invalidate those federal forum provisions. The Delaware Chancery Court disallowed the provisions and said they were invalid, but the companies appealed to the Delaware Supreme Court. And a few weeks ago, in a decision usually referred to as the Blue Apron decision, the Delaware Supreme Court said that these federal forum provisions are facially valid, meaning that for Delaware corporations that adopt their articles of incorporation, they can seek to have any state court lawsuits that are filed dismissed in favor of a federal court forum. Obviously, not every public company is a Delaware corporation, and in fact, many of the companies listed in the U.S. are not even domiciled in the United States. But for the Delaware corporations, this is, as you said, Harold, a very good development, and it substantially increases the likelihood that those companies will only have to litigate Section 11 cases in federal court and not be forced to have duplicative litigation. So very, very definitely a positive development for corporations incorporated in Delaware.
Well, Andy, as a follow-up question to you, do you think that a legislative codification of this Delaware Supreme Court decision, let's say in other states that want to attract corporate headquarters and corporate formation, could be a potential solution, at least on this Scion decision that came out of the Supreme Court?
Certainly, unless and until Congress acts to hopefully move all of these cases back into federal court, I think that's the best tool for eliminating abuse. And, you know, I think it's important to recognize these forum selection clauses don't prevent anyone from filing a lawsuit. All they do is say you can't double up on the company's litigation burdens by filing cases in federal court, in state courts, maybe in multiple state courts, as a way of exerting settlement pressure, and that consolidating them all in one place makes a lot of sense. So you would think that, like Delaware, other states that want to be fair, frankly, to companies, but also to the company's shareholders who foot the bill for this litigation, it would be a pretty sensible move.
Thank you, Andy. Moving into another area, and this is interesting to me, just given some of the historical abuses that have happened. I mean, I think many of us on this call remember the indictment of the Milberg Weiss firm for giving kickbacks to lead plaintiffs in their securities litigation back in the mid-2000s. I think it was the Central District of California, the U.S. Attorney's Office there, that pursued an indictment for some of these shenanigans. And it seems like we've seen elements of this in the so-called State Street litigation. It's been one of the more controversial dramas that we've seen, at least in recent years. It's somewhat complicated, but it does involve the recruitment of a pension fund down in Arkansas. And Andy, I'm wondering if you could give us a quick snapshot of this case, and we could talk a little more about it in the context of current events.
Sure, and people may remember that one of the things that the Private Securities Litigation Reform Act did to try and deal with this recruitment of what was called at the time sort of pet professional plaintiffs that really didn't exert any oversight over lawyers was to say, well, gee, the solution here is to put institutional investors in the driver's seat in litigation. They'll exert control over the lawyers, and we'll have client-driven litigation, not lawyer-driven litigation. As it played out in practice, there has been some involvement by institutional investors, I think a lot less than anyone thought. And increasingly over the years, there's been concern that the way the plaintiffs' bar has adopted to this strategy has been to engage in what Professor John Coffey of Columbia has called, the sort of the practice of buying and selling plaintiffs, establishing relationships with the elected officials in charge of government pension funds, and then using those government pension funds as the plaintiffs in litigation. There hasn't really been any direct evidence of this, but there's been a lot of indications that may be the case based on political relationships between plaintiffs' law firms and the government officials overseeing the pension funds that they represent. But this State Street case really dug into it. And it takes, as you say, it's a little complicated. And the first thing to say is it's not a securities class action. It's an ERISA action, but an ERISA action brought by lawyers who specialize also in securities class actions. What happened was it was a case that passed the motion to dismiss stage. There was a settlement. There was an attorney fee award of around $75 million on a $300 million settlement. And then there were some concerns raised about the attorney's fees award and whether there was some duplication in terms of the different law firms involved counting some of the same legal work twice. And so the district court appointed a special master, former judge, to investigate. And he found a lot of things. And what's happened recently is the district court has entered its order reducing significantly the attorney's fees, but also, and I'll just quote a couple of sentences about the findings here. What the district court said is that it found a troubling disdain for candor and transparency that at times crossed the line into outright concealment of important material facts, and then also a web of concealment and highly questionable ethical practices by experienced attorneys who should have known better. And the district judge, in addition to reducing the attorney's fees, referred the entire matter to the Massachusetts bar disciplinary authorities. This was a case in district court in Massachusetts. And one of the things that was uncovered was a payment of $4.1 million to a lawyer in Texas who the district judge said had done no work on the cases and whose role had been to introduce the plaintiff's law firms to some Arkansas elected officials who oversaw the plaintiff in the case, the Arkansas Teachers Retirement Fund. And one of the findings of the district court was the arrangement between this lawyer and the lawyers in the case was that this lawyer would get 20% of the lawyer's fees in any case in which the fund was a lead counsel and the case was either settled or resulted in a judgment. The court found that there were political relationships between these go-betweens and the government officials who oversaw the fund. It didn't go into those facts It also found a similar type of relationship with a lawyer in Massachusetts relating to a Massachusetts government pension fund. So I think what happened here is that for unrelated reasons, the rock of attorney's fees requests was picked up, and underneath we found some quite unseemly conduct going on that confirms a lot of the concerns that people have had about whether the PSLRA's reform about trying to put clients in charge of litigation is really working, or whether there's really been quite a significant workaround found to that protection.
Andy, it's funny when you read the quotes from the special master, it sounds a whole heck of a lot like asbestos litigation, lack of candor, misrepresentations. I wonder if there's a pattern here. And Kevin, I'm going to turn it to you. Just your thoughts on this, but also, is this just the tip of the iceberg in terms of what we're seeing with some of these questionable and dubious arrangements that now have seen, at least one special master report? How pervasive is this?
Well, you do have to worry, given the number and kind of misrepresentations that the special master uncovered, whether this is just a one-off problem or it suggests there's a more pervasive problem, which to me leads to a thought that when you have a class that's represented by these individuals, and at this point in the process, arguably a conflict of interest between the class and the plaintiff's lawyers, because the plaintiff's lawyers are interested in maximizing their fees, that the judge has to take a more active role to protect the interests of the absent class. And Andy read a couple of statements from the opinion. I had one that I wanted to read, where Judge Wolf said in his February 27th order, "This case demonstrates that not all lawyers can be trusted when they're seeking billions of dollars in attorney's fees and face no real risk that the usual adversary process will expose misrepresentations that they make. Therefore, making fee awards and class actions, it is important that judges are skeptical and do the hard work necessary to protect the interests of the class and the integrity of the administration of justice." And I think there's a lot of truth there, that it's incumbent on the courts to recognize this conflict of interest between plaintiffs' lawyers and the class at this point in the process, and to take a more active role, and where appropriate, as happened here, have a special master appointed to investigate and make sure that what finally is decided with respect to attorney's fees is fair and appropriate.
Thank you, Kevin. Thank you, Andy. I think that we're going to start taking questions from our audience. We're getting a steady stream of questions, and I'm going to start with one that came in from Anonymous, but please don't feel as though you have to disclose yourself. Here's the question: how successful have defendants been in getting discovery in state court using arguments based on the PSLRA? And I think I will direct this one to you, Andy.
Yeah, I mean, obviously, the PSLRA doesn't apply in state court, so that's a problem to begin with. And I think one of the questions here, just to back up a little bit, as people probably know, one of the protections put in place in the PSLRA was a discovery stay prior to the decision on the motion to dismiss that set a pretty high bar for allowing discovery, because of the recognition that a technique that was in use at the time was the use of discovery and infliction of lots of high discovery costs on defendants as a tool for forcing settlement. I think it depends on the district judge whether there's going to be success in arguing from analogy that discovery stay should apply even though the case is in state court. But you would hope that district judges would recognize Congress's determination, but there's no assurance that they will. And it's one of the many problems with transplanting this litigation to state courts, where there's a lot less experience and a lot less controls, because often state courts are not faced with this kind of very, very, very significant litigation.
Unless you're Delaware, of course. They seem to have a healthy body of law. Kevin, do you want to address this question?
Well, Andy is right that I think that state courts are struggling with this question of whether or not they should recognize the discovery stay. And I think it's indicative of the problem that in both New York and California, where most of this litigation is getting filed, that you can find state court decisions on both sides of this issue, which is hardly ideal to have different outcomes on this question of whether or not discovery is going to be allowed when it wouldn't be allowed in federal court.
Okay, thank you, Kevin. Here's another question, which is coronavirus related. The current coronavirus crisis might drag out into the fall or into 2021 with waves of the pandemic potentially. Are there any securities liability parallels that arose from the 2008-2009 financial crisis or even post 9/11? Specifically, is there any other example of a lingering crisis driving litigation which we might want to consider here? And Kevin, maybe I'll start with you and then I'll move on to Andy.
Yeah, it's actually a conversation we're having in the insurance industry a lot. You know, what is the historical parallel we can use to try and assess where we are? There's a lot of conversations about how this might compare to the global financial crisis from 10 to 12 years ago. There are important differences, but one way that I think they could prove to be similar, and this was echoed in the question itself, that this crisis we're in could drag on, and certainly the economic consequences could drag on far beyond the health crisis. And for those of you who can remember how it all played out in the global financial crisis, the lawsuits that arose did not just come in 2008 and 2009. We were still getting financial crisis related lawsuits in 2012, 2013. You know, my crystal ball is no better than anyone else's. But what I'm afraid of is that we will see that again, that we will see a multi-year phenomenon of not just the coronavirus health crisis related lawsuits, but more importantly, coronavirus economic downturn related lawsuits going ahead for the next several years.
Andy, do you have some thoughts on this question?
I think the thing that makes this situation even scarier is something that Kevin alluded to earlier, which is it's very uncertain what's going to happen here just in terms of the underlying health situation. You know, in 2008, we had a crisis. It wasn't clear when we were going to pull out of it, but there weren't multiple crises once we sort of got through that initial period. Here, it's very possible that we could see a downturn in infections sometime in June, but at least in some parts of the country, you could easily see an uptick once businesses start to reopen. And so companies could say things based on what they believe at the time in terms of recovery to their business that then might turn out not to be true, not because there was any intent to mislead or fraud, just because the underlying course of the virus is very uncertain to predict. And so that really opens up a whole new opportunity for arguments in litigation that the company should have known that this was possibly going to happen. And so you can see a wave of potential litigation one after another.
Yeah. Here's another question. What, if anything, can state legislators do until Congress and or the SEC acts to confront some of these major securities litigation challenges? I will start with Andy.
I think it's hard for state legislators to do anything. I mean, certainly one thing state legislators could do, thinking about what Kevin said about the uncertainty of court decisions regarding the procedural protections that are incorporated in the PSLRA, is to instruct state courts, to the extent they are getting these 33 Act claims, to adjudicate them in the same way a federal court would under the PSLRA. That would at least solve one of the problems. Another way to do it, frankly, might be to instruct the state court, if there are parallel federal actions, to stay the state court action until the federal action is concluded, which would be another way of saving the company's shareholders from having to pay double defense costs.
Kevin, do you have any thoughts on this question?
Well, I am pushed back to being practical about this. The two most important states to deal with this are California and New York. And right. I'll leave it to the audience to decide what they think that those legislatures might do on this issue. I actually think it's likelier that Congress will act to amend Section 33, then that those state court legislatures will actually do anything to address this issue. And again, you can assess for yourself what the likelihood is of this Congress addressing this issue.
Okay. Here's another question. What types of companies are most at risk for securities class action litigation? We've certainly seen the two companies as of last month who were sued. I think it was a drug manufacturer and Norwegian Cruise Lines, but who else can you foresee sort of in the crosshairs of the class action securities litigation plaintiffs?
I'll take that one. Obviously, in my industry, that's a really important question right now, and a lot of D&O insurance underwriters are scrambling to try and come up with an answer to that question. You can certainly foresee that the ones that are most disrupted right now, airlines, hotels, casinos, chain restaurants, movie theaters, that those are going to be at risk both in terms of specific litigation risk, but also financially. I don't think it's contained just to those areas, and I think the financial risk stretches to all parts of the economy. I mean, any business that's interrupted because of a governmental stay-at-home order is going to see a massive disruption of their revenue, which creates cash flow and liquidity issues, and that in turn could lead to the possibility of claims including disclosure type claims like we saw against the cruise line and the biotechnology company. I think if we take a long-term view of the next 18 to 36 months, it's going to spill far beyond, the airlines, hotels, and casinos, and affect potentially a lot of other kinds of companies.
Yeah. Andy, do you seem in agreement? I saw you nodding your head.
I think that's right, and you could see a second wave. I guess I would add the pharma companies into that, just because even before this all happened, they've been a particular target, pharma and biotech companies, of securities litigation. So you think that would only pick up. And I think you can see, again, taking a longer view of problems possibly spreading to the financial services sector. There already are articles about debt and what will happen if some of the companies that Kevin talked about are unable to meet their debt obligations if this persists, or depending on what their cash situation is.
Well, gentlemen, I think that wraps up all the questions we've received up until this point. I want to thank you for joining us today. I want to thank all the participants for taking time out of their day to join us on this very first inaugural ILR Briefly on securities litigation. Rest assured that we have much more content in the pipeline as we address some of these major issues, emerging liabilities, certainly in the wake of the coronavirus outbreak. These are massive issues that we will be taking a careful look at as part of the ILR program. We think it's incredibly important to start flagging these issues now in piecemeal, but also as part of a comprehensive communications effort. Unfortunately, we couldn't all meet together to have a discussion in person, and we will adjust to this new normal by ensuring that we can meet virtually like this and to improve on these technologies, because it is important for the business community, for the legal community, for judges, for policymakers to understand these increasingly complex issues of litigation, whether in securities, in mass torts, product liability. Rest assured, again, that more will be coming down the pipeline, and we do appreciate everyone coming on board to join with this good discussion. So please join me in thanking Andy Pincus and Kevin LaCroix. Guys, hopefully we don't have to wait another year like we did last year at the National Press Club in order to convene again. And we do have a lot of work ahead of us to ensure that we can contain the spread of the securities litigation and to address the business community concerns in these challenging times when it comes to this pandemic. Thank you very much. Have a wonderful day. And by all means, please go to our website to look at a lot of these products, among other things. Thank you.